Joining us now, Ian Millhiser. He is the justice editor at Think Progress. Ian, thanks for joining us. How are you?
It's good to be here, although not the greatest day I've ever had right now.
Yeah,
Yes,
no,
of course, yes.
clearly not a great day, but I guess, I mean, obviously a necessary day to kind of understand and put into context. We want to start with the Harris-Quinn decision, and really this is a very significant decision, obviously, for public sector unions. And I think now, just as the decision is coming down, and maybe in the last couple of days, there was some heightened awareness about it. But you wrote a piece a while ago, basically saying this is. Maybe not the major decision of this cycle, because there are a number of very significant decisions, but this was the one that was sort of under the radar, that was going to pay very significant dividends kind of coming up, and now it's done. So why don't you situate this case for us, tell us what was at stake, and then we'll look at how the 5-4 right-wing majority went about basically handing a significant defeat to the public sector unions in this case.
Sure thing. So this was an effort basically to defund public sector unions. The way that unions are financed is if you belong to the union, you pay dues. And if you don't belong to the union is still required to bargain on your behalf. So any higher wages, any increased benefits that the non-members get, that the members of the union get, the non-members have to get them too. In return for these benefits, the non-members often have to pay what are known as agency fees, and that just reimburses the union for the cost of bargaining on their behalf, so they're not getting something for nothing. This case sought to say that the plaintiffs tried to get the court to say that in all cases dealing with public sector unions, they're called agency fees, these fees reimbursing the unions for the benefits they give to non-members, are unconstitutional. And the court didn't go quite that far, right, but they said that for one of the most vulnerable sets of government workers, these fees are unconstitutional, and that's going to make it very hard for unions to operate, because, if people can get something for nothing, they're going to take something for nothing, and there's going to be little incentive for people to pay the unions for what they're providing these workers.
Right, which of course will fundamentally undermine the union's abilities to sustain themselves and do those organizing and negotiation efforts to begin with, which benefit the workers who are essentially, it's a free rider problem. So, what would be the clearest analogies to draw? Because it seems there's one very, very simplistic way that the right frames it, and that frame is the unions are just taking money out of your pockets. It's not democratic, and regardless of your choice, they take the money, right? That's the frame, and that's kind of what the court sided with, essentially, in some respects, at least with regards to these workers, and we'll get into those distinctions later. But the much better and more appropriate way of thinking of it is you're dealing with, as you say, basically dealing with a free rider problem, which is that the union negotiates these benefits that impact and improve everybody's lives, and you need it. So is an analogy like paying a toll for road maintenance, or something that is a public benefit that you're gaining from, and it's it's not entirely on the house. You have to pay something into it.
Yeah, no, that's exactly right. What the issue is here, these union non-members, members and non-members, the workers at issue in this case, were making $7 an hour before the union came along. Right. And once they unionized, they started making over $11 an hour, and thanks to the union, they're set to get a raise in December, where their wages will go up to $13 an hour.
Right.
So their wages nearly doubled because of the union. They will earn nearly twice as much as what they once earned because of the union. And the idea that it's some great imposition on someone who just had their wages nearly double,
right,
to have a small fraction of those increased wages taken out of their paycheck in order to reimburse the union that got it for them in the first place. It's a ridiculous assertion, and it's a very damaging assertion, because ultimately what this does is it enables what you call free riders. It enables workers who want something for nothing to get all of these higher wages without having to pay for it. And ultimately, the workers who will be burdened with those costs are going to be the responsible workers, the workers who join the union and say, I am getting something, and so I am going to pay my fair share to make sure that this sticks around for all of us.
Yeah, I mean, it's a classic commons problem. I mean, you're taking advantage of a public good that's created, in this case, the higher wages by the union, and then not paying into it and not supporting and sustaining it in any way. I'm curious if we could go to the personality of this for a second, and then we'll get into more of the broader specifics of how the court actually made this distinctions and what they tried to do with it, how they attempted to maybe draw a slightly more narrow. I mean, they did draw a more narrow decision than they could have, but how, given the context that what the union did and what this legislation did in Illinois, essentially, as far as I understand it, is it took workers. This woman, Mrs. Harris, basically was staying at home taking care of her son who had a rare degenerative disease. She was getting paid through Medicaid, and so the unions agitated, and the governor, Quinn, signed a bill basically saying this woman is a state employee because Medicaid is basically paying her to do what she's doing. So therefore she's eligible to be represented by the union, not, be forced to join, incidentally, or pay dues, but can be represented, as far as I understand. And then she accrued these benefits, which we were just talking about, 7 to 11, and then 13 would have been next. What was the impetus for her personally? I mean, how was she enlisted in this crusade? Which, I mean, I don't know, maybe it will benefit her personally in some ways, but it's sort of, on the whole, it's extraordinarily bad for people like her, and maybe her too. I mean, I don't know what the end result for her is. Do you have any sense of? I'm always fascinated by how someone gets enlisted as a kind of guinea pig in a crusade like this.
Yeah, I mean, she was the ostensible plaintiff. There were 8 people who were these home health care workers who say they object to this arrangement. But the real plaintiff here is an anti-union litigation shop called the National Right to Work Legal Defense Foundation, which, goes all over the country looking for lawsuits it can file to try to undermine unions. Right. And they found a big one here, and they just scored a big victory. What I think you have to understand about the context of this case, so what happened here is it used to be that people on Medicaid were frequently institutionalized, and that's a bad place to be.
Right.
You don't want to be in an institution if you can avoid it, and so we've seen a trend towards non-institutionalized home care, and that's a very good thing. But these home care workers tend to be very poorly paid. And if they're poorly paid, you're not going to get a high quality of worker. It's going to mean that the quality of care is going to be very poor. And so in the process of trying to do this very good thing of moving people out of institutions, we can wind up having worse outcomes if we don't have good people who are well compensated because they are good people, providing care to what are often our elders.
Right.
If we don't have unions, these people will not be well compensated in many cases. And ultimately, the people who will pay the price will be the patients, typically very helpless elderly patients who depend upon these workers and who deserve to have the best possible care workers they can get. And if you want good care workers, you have to pay them like they're good care workers.
Right, absolutely. I mean, this is the McDonald'sization of elderly care. I mean, that's the in addition to the anti-union push, that's the broader policy consequence that almost anybody who could be in a situation like this with elder care or something like that can feel, no question about it. So, what did the court actually do here? They could have gone farther, but they did go pretty far. What did they actually do? Break that down for us.
Sure. So what they could have done is they could have overruled many decades of precedent saying that in all public sector unions, so unions for cops, unions for firefighters, all of your government unions, these agency fees are allowed. They could have tossed out these agency fees entirely, and that would have threatened all public sector unions. I mean, that would have been an existential threat to many public sector unions. They didn't go quite that far. They said that for these unusual arrangements where you have workers who are paid by the state but work directly for an individual, which is what you have with these home health care unions, in those cases the court said that these agency fee arrangements are not allowed. And then they had this ominous language where they said that agency fee provisions, this is the court's language, unquestionably impose a heavy burden on the First Amendment. So they're hinting that, right now we're just taking this away, we're just taking unions or undermining unions for these Medicare and or for these Medicaid and home health care workers. But tomorrow, cops, we may come for you. Right. Firefighters, we may come for you. That's the upshot here, is that they are at least staying the execution of many of these public sector unions, but the next decision could have much broader implications.
Right, and then and is that really the very, very dangerous trend that I know you've talked about and written about, and we've seen this in a number of different areas. Haley Sweetland Edwards was on this program a couple of months ago talking about basically perversions of the First Amendment to undermine OSHA regulations, something as simple as posting a notice on basic workers' rights in a cafeteria of a corporation, as an example, or even more kind of darkly, hilariously, someone, a Wall Street firm actually saying, well, complying with an aspect of financial regulation violates our First Amendment rights because we don't want to exercise our speech, So is this kind of, and I think the phrase is weaponizing the First Amendment, is this the path is this the way this kind of, and I think at this point it really is clear to call it this very far right judicial activism, is that the kind of is that the context provider for all of these assaults we're going to see? Is this it's like once you establish that, go ahead.
Yeah, that seems to be where we're going. I mean, Justice Breyer pointed out in oral argument that this was an attempt to turn the First Amendment into a weapon that conservatives could wield to tear down laws that they don't like. And it's really turning the First Amendment on its head. The purpose of our First Amendment is to ensure robust debate. It's to ensure that ideas aren't suppressed, so you and I can hear the different ideas that are out there, can hear the different proposals that people might have for what might make good policy. And then when we go to the polls, we can pull the lever and we can make an educated choice. The purpose of the First Amendment is so that we have the full field of policy choices laid out for them, and those choices aren't made for us in advance by the government stepping in and saying, no, you're not going to get to hear about this idea because we don't want you to choose that one. What the court did today is they said that the First Amendment mandates a particular anti-union policy. That is the opposite of what the First Amendment is supposed to do. The First Amendment is not supposed to take our choices away from us. The First Amendment is supposed to lay out the full menu of policy choices that are available so that we, the voters, get to make that choice and not 9 unelected people who sit in a marble palace in Washington, D.C.
Well, right. And just, to add really briefly to that, and then we'll get to Hobby Lobby, but I think it's also setting up these inversions. If we go down this road where weaponizing the First Amendment, and I don't want to disclose this policy that we conduct as a financial institution, or I don't want to disclose, frankly, this chemical that we're putting by your water supply when we're doing drilling exploration or fracking or something like that. There's no inverse. I mean, you're not going to start being able to say, well, I don't want to give my credit score as part of this application for this credit, or I don't want to disclose this personal detail about myself. We're going to have this completely inverted world. We talk about, with things like bailouts, socializing losses, privatizing gains. We're going to turn, we're going to be in a road where we have a sort of very high personal transparency and vulnerability in institutions, even as institutions get more and more insulated. And it just seems like as you say, astonishing, just kind of turning everything on its head, and the trend is, not only ominous, just kind of, I guess, just sort of mind-blowingly cynical.
There is no limit to what happens if the court is willing to fully weaponize the First Amendment in this way. I mean, the most ridiculous lawsuit I've seen, there's a lawsuit that was just filed challenging Seattle's minimum wage law. And the theory, I'm not making this up, the theory of this lawsuit is that the minimum wage violates the First Amendment because every dollar that is spent paying workers is a dollar that McDonald's can't use to buy advertisement. That's their theory, that the minimum wage suppresses their speech because they have to pay a fair wage to their workers, and that means they can't afford to buy more ads for the Big Mac. And this isn't some podunk attorney who filed this lawsuit. This is Paul Clement, who's practically the Solicitor General of the Republican Party.
Yep.
So, they are thinking big when they think about weaponizing the First Amendment. And, like I said, the First Amendment is supposed to preserve our policy options and ensure that we know about all of them. It's not supposed to take them off the table for us.
Absolutely.